уделили время нашей сегодняшней встречи. Я бы хотел сказать пару слов для того, чтобы обозначить контекст. Но прежде всего я хотел бы сказать, почему Ричард оказался в России. Надо сказать, что в России, несмотря на важность информации для развития бизнеса, не так много юристов, которые работают с информацией, не так много юридических фирм, которые достаточно легко могут решать юридические вопросы. И в этом смысле коллегия медиа-юристов, одна из таких фирм, попросила Ричарда помочь разработать стратегию развития медиаправа и медийно-правового сообщества в России. Соответственно, Ричард согласился приехать в Россию на 3 недели для того, чтобы помочь это сделать. Несколько слов о Ричарде Winfield как одном из лучших, на мой взгляд, в мире медийных юристов. Надо сказать, что в мире не так много крупных юридических фирм, и вот Ричард долгое время работал юристом и партнером Clifford Chance, который это одна из 5 крупнейших в мире юридических фирм. Возможно, Ричард об этом скажет чуть позднее подробнее. И поскольку вот постоянно работая с российским бизнесом, не только медийным, но и в целом тем, для которого информация составляет существенную часть капитализации, мы обратили внимание на то, что подход к управлению правовыми рисками в информационно-правовой сфере чрезвычайно различен для России и для США. В России, по большому счету, любой бизнес может быть так или иначе подвергнут очень серьезным опасностям в том случае, если с правовой точки зрения не просчитаны информационные риски. Не знаю, какие примеры привести, но, скажем, я полагаю, что какие-нибудь IT-компании, которые у всех на слуху, там типа ВКонтакте или Одноклассников, можно вполне найти законные способы ликвидировать их бизнес-модель в связи, например, с ненадлежащим оформлением вопросов, связанных с персональными данными. Или если мы будем говорить о каком-нибудь другом IT-бизнесе, то вполне можно придраться к другим вопросам. И в этом смысле у государства есть очень серьезные способы прекратить работу той или иной компании, в том числе имея в виду информационную сферу. Кроме того, я уже не говорю о том, что коммерческие секреты, коммерческая тайна в России почти не защищена, и вот зачастую бывает сложно предотвратить ситуацию, когда работник, уходя из компании к конкурентам, например, уносит с собой базу данных со всеми клиентами или копию какой-то документации, которая чрезвычайно чувствительна для фирмы. Способов управлять этими процессами российское право предоставляет не так много. Что касается Соединенных Штатов, то, разумеется, там расходы на юристов больше даже не в разы, а на несколько порядков. И в этом смысле вот у нас есть возможность поговорить с Ричардом Уинфилдом, который обеспечивал лучшие информационные медийные компании, лучшими в мире юридическими услугами, причем в качестве того, кто организует этот процесс. Ричард говорит, что он гордится тем, что он смог предотвратить ситуацию, что за 35 лет, пока их клиентом был Associated Press не пригласил своего домашнего штатного юриста, что показывает, в общем, что услуги юридической фирмы Ричарда его устраивали. На этом я бы хотел закончить и передать слово Ричарду. Floor is yours.
Thank you, Fedor Kravchenko. My name is Richard Winfield. I'm visiting Russia as a guest of Fedor and the Media Lawyers Collection. He's been a wonderful host, and he will return, or I hope to return the favor when he visits New York at the end of this month, and share experiences and share know-how about the media. I thank you for this invitation to talk with you today. this opportunity, and as a part-time professor of law, Columbia Law School and Fordham Law School in New York City, I enjoy very much interacting with and teaching students, and I derive a lot of energy and a lot of excitement and challenges from working with students. So I thank you for your interest, and I do hope that you will interrupt and intervene and ask questions or offer comments as we proceed today. By way of background, I studied English literature in university for 4 years. I spent 4 years in the United States Navy as an officer. I then spent 3 years at Georgetown University Law School in Washington, D.C. I came to New York City and started practicing with a large law firm. I did commercial work. Then I served in Albany as an assistant counsel to then Governor Nelson Rockefeller for 2 years. Then I came back to New York City and joined the firm of William Rogers, the firm of Rogers and Wells. And he is the man who was the Attorney General of the United States under President Eisenhower. And then he came back and was a prominent media lawyer, and I learned at his feet how to practice law, how to represent the media, how to protect the media, how to deal with reporters and editors, and how to represent the government, how to represent the press against the government. And in those days, at the time of the Vietnam War, the government was seen as an adversary of the press, and the relations were tense and difficult, and it was a great challenge and a great honor to represent the press in those difficult days. So I became general counsel for the Associated Press after William Rogers went into the Nixon administration as Secretary of State, and then I served as a media lawyer for numerous large and small media clients, and then I began teaching on a part-time basis media law, and I now formed an NGO, and we do assist journalists in democratizing countries to reform their media laws, to keep journalists out of jail, and to provide for transparency in government. For instance, through the adoption of freedom of information laws. So that's a bit of background about me, and let me just suggest that in tonight's discussion, and I hope it's a discussion, I hope it's a two-way discussion, I'd like to open the discussion by suggesting that we'll focus on the financial and economic side of the media industry. And some of the topics that I propose that we discuss are issues dealing with ownership and limitations on ownership, and some anti-competitive and antitrust issues that flow from that. I want to talk about the taxes on the media. I want to mention something about the role of government advertising in the media, or subsidies of the media. I'd like to discuss with you in the United States, the scheme whereby broadcast stations, radio and TV, these are over-the-air terrestrial stations, receive licenses from the government, and the comparison between the scheme of very light touch regulation that is characteristic of the United States compared to a system that you're familiar with entities such as Roskomnadzor. In that connection, we will consider the role of the government, the Federal Communications Commission, on imposing limitations on the number of stations a single corporate owner can own. That's radio stations or television stations and cable. We'll look into the obligations of cable systems to carry broadcast signals. We'll look into limitations of combined newspapers and television stations in the same market. We'll look at some copyright issues and a new emerging area that is associated with copyright called the hot news doctrine, or the misappropriation of content by one competitor against another competitor and using and passing off that information as his own. Another source of major financing and revenue support of television stations is the enormous amount of dollars spent by politicians during election campaigns and the dependence of the broadcast industry on those dollars. And I'll try to talk a little bit about the turmoil and the restructuring that's going on in the American media industry. So those is a sampling of some of the topics I would like to discuss with you. And again, I invite you to offer your own views and interrupt and intervene at any point. Starting with the issue of ownership. The ability of investors and corporate interests to amass editorial voices. Let's start with the newspaper industry. There are about 22 major groups or chains of newspapers. Some of them include Gannett, New York Times, Cox, McClatchy. These 22 largest command over 50% of the daily newspaper readership. It is a function, it is a characteristic of the American newspaper industry that there are only a very few cities with competing editorial voices in the newspaper industry. In other words, there are very few cities, only the very largest cities have two competing newspapers by two competing entities. For the most part, the American public is served by monopoly newspapers, and that is just a product of the competitive problems and the decline in newspapers. They still have tremendous political clout. Politicians seek the editorial endorsement of the local newspapers because of the stature that it grants them. The antitrust regulators have been very reticent, very unwilling to challenge these combinations or chains or groups of newspapers. It happens only very rarely that there's an antitrust suit against a newspaper. A case in point, in Florida, a large daily newspaper gathered up and bought up all the free circulation daily newspapers in its readership market, thereby driving out competition for advertising. The Department of Justice brought a lawsuit, and the government prevailed and required the newspaper, the large daily newspaper, to unravel the deal and restore the status quo ante because of the impact on competition that would be adversely affected by a single owner controlling all daily circulation in a particular newspaper market. That would, I think, cover the important issues with respect to the newspaper market. Let me address television broadcasting. There are perhaps 8 or 10 large corporate entities that own the bulk of the television broadcast stations. They are subject to limitations. Only in the largest cities can a single owner could own more than one license. And there's a cap on the readership or the audience share that a single corporate owner can command in terms of his ownership of television licenses throughout the country. No single corporate owner, by act of Congress, can own more than 39% of the national audience. So there are two caps, a locality cap and a national cap. The locality cap depends on the population of the market. The larger the market, the more possible it is that there can be more than one owner, more than one station owned by one owner. And the national cap, it was a political judgment. And the concerns, the interests that the Congress and the Federal Communications have, this is the regulator, is to preserve a diversity of voices, a multiplicity of voices, a plurality of voices, to protect the possibility of local news, local coverage. Third, to impose some restraints, some restrictions on a concentration of ownership. And the fourth criterion was to encourage and enhance competition. And it was these four interests, these four concerns that are always at issue in determining whether a single owner, like, let's say, Hearst Corporation or American Broadcasting Company or Rupert Murdoch can own additional broadcast licensees. With respect to radio stations, I'll say more about this later, the national caps were eliminated so that there is no limit on a national basis of the number of stations that a single corporate owner can own. And it might be worthwhile to explain why that national cap was eliminated. In the old days, no single owner could own more than a few dozen radio stations nationally. However, in the 1990s, the situation developed that the radio industry was losing money. 60% of the industry was in financial difficulty. And in order to provide economies of scale, to encourage competition, to encourage local coverage, and to preserve the industry, Congress eliminated the caps. So a single owner could achieve economies of scale, so that now a single owner called Clear Channel owns over 1,200 stations throughout the country, commanding about 27% of the audience market share. Also, in 1996, when this cap was removed by Congress on a national basis, the Congress also directed the Federal Communications Commission to expand and liberalize the number of stations in a single market that a single owner could own. For instance, in the largest cities, a single owner could own about up to eight stations. Similarly, with respect to cable, there have been attempts by the Federal Communications Commission to limit the number of subscribers that a single cable system could own nationally. That has been challenged in the courts, and the issue remains unresolved. So there's a tension between the efficiencies of scale, the need for competition, the need to protect local industry and local news coverage, and diversity of voices, the multiplicity of voices. So this is a work in progress. No one in the media field is satisfied with the status quo, because the markets are changing so rapidly, and so in such an unusual fashion, because of the impact of the internet, that I foresee more changes down the line. But at all times, these four factors will be uppermost in the minds of the industry, and the Congress, and the regulators. I'll speak a little bit more about the FCC licensing regime in just a minute. I wanted, because I mentioned taxes as an issue that obviously impacts all forms of the media. Federal taxes, state taxes, and local taxes. There seems to be no problem with respect to the uniformity and the equal application of federal corporate taxes on corporations, whether they're media corporations or non-media corporations. So federal taxes tend to be a non-issue. State taxes on different platforms becomes a controversial issue. A sales tax on use of, or use tax on use of paper and ink for a newspaper, or a gross receipts tax imposed by the state on all revenues received by a media entity. Here, state legislatures have experimented with different taxes on different platforms. A sales tax on cable subscribers' income, but no sales tax on newspaper sales. And of course, these disparities are the result of lobbying by the newspaper lobbyists, or the cable lobbyists, or the radio and television lobbyists. So there's a crazy quilt of conflicting and disparate laws. And these laws, these tax laws, can have a disparate impact. And if there's a disparate impact, let's say a newspaper, or more likely a magazine, will claim that its constitutional rights of free expression were violated by their requirement to pay heavy taxes, where a competing platform is exempt from such taxes. And so the courts have struggled with attempts to reconcile, on the one hand, the ability of state legislatures to impose taxes fairly on the one hand, and on the other hand, in a way not to impose discriminatory impacts on platforms. Generally speaking, it's okay under the Constitution for a state legislature to tax different platforms, such as I mentioned, newspaper subscription revenue versus cable subscriber fees. That has passed constitutional muster. But if a sales tax or a state tax of any kind is imposed within an industry, within a platform, and if there is provable discrimination, then that tax is likely to be struck down as violating the Constitution by interfering with the freedom of expression of the tax entity that pays the heaviest tax. For instance, in the 1920s, there was a populist governor of the state of Louisiana who was a demagogue and who controlled all of the state, including the state legislature. He was supported by the small newspapers in the upper part of Louisiana. His demagogic policies were opposed by the big newspapers like the New Orleans Times-Picayune downstate in the southern part of the state. The governor, Huey Long, got his state legislature to pass a law that imposed a sales tax on newspaper sales revenues for all newspapers with a circulation of 20,000 readers or more. You can see why he did that. He wanted to reward his friends and punish his enemies, as only politicians wish to do with respect to their friends and enemies in the media. But this was a particularly blatant tax scheme. The small newspapers paid no taxes. The big city newspapers down in New Orleans had to pay. The newspapers downstate challenged that state tax law in the United States Supreme Court, which found, to no one's surprise, that the law violated the First Amendment. It unfairly imposed a tax on some, and the political characteristics of the law were obvious to all, and the court said that state sales tax law operated as a prior restraint. How? Because it put pressure on an editor to reduce his press run and not go over the 20,000 limit. And that reduction of the press run interfered with the free flow of information. And if the American First Amendment of the Constitution means anything, it means that there should be no impediment in the free flow of information. So taxes and the government's ability and willingness to impose taxes can form a shadow kind of regulation, in which we, as media lawyers, are very conscious of examining: is there discrimination? Is there disparate treatment? Is there a political motive behind this tax law? Is the government rewarding a friend and punishing its enemies? And if we find that, we go to court and challenge that tax law as being violative of the Constitution. I myself have acted as a lobbyist in Congress to secure equal treatment of my client. This is when the Congress was reforming our tax code. There was a disparity. My client, Associated Press, was paying at a higher rate of tax because of its unusual corporate structure as a not-for-profit cooperative, whereas its regular stock corporation competitor, United Press, was paying at the low corporate rate. Now, we chose to go to Congress rather than go to court because the whole tax code was being revised, and we prevailed upon a New York Senator, Daniel Patrick Moynihan, to carry this bill that would equalize the treatment so that our client, Associated Press, was not unfairly taxed at an unfair rate, so that it could compete fairly with its stock corporation competitor, so that at the end of the day, the taxes for a stock corporation and a not-for-profit corporation in the same line of business were the same. This was a very interesting exercise to appear before Congress, representing a news organization. And the legislators knew full well that this was their coverage by Associated Press was not going to be improved or reduced by virtue of the way that they acted or voted on this particular bill. Let me address for a moment the question of advertising by government in the media. In the United States and in much of the world, the smaller media platforms are heavily dependent on advertising by state corporations, by the state, and that forms a basis of economic dependence, which is unhealthy. How can you address that? The capacity of government to place ads or to pull ads and to reward friends and punish enemies is a very powerful and very dangerous tool. It can be something as fundamental as a city or town or village is obliged under the local law to publish notices of hearings on zoning changes or routes for new highway construction or creation of a new school district. The government is obligated by law to place those ads, and the industry, the newspaper industry in particular, is anxious to fill its pages with that tiny print so that they can get the revenue from the state to support their editorial activities. Now, who gets those contracts? Is there a contract, is there a bidding process? At least one newspaper in a market should be obligated to print those legal notices. But how is that newspaper selected? Because it editorially supports the ruling party in the community, or because the mayor and the publisher are friends? It should be open and transparent and non-political, and there should be competitive bidding. At least that's the process that we find is the most democratic, the most honest, most open, and the most fair. And it remains true that small newspapers in the United States need that revenue. Now, I mentioned the word subsidies earlier. The American newspaper broadcast, in fact, the entire media industry is characterized by the absence of subsidies by the government. All newspapers, all radio stations, all television stations, all cable systems, all ISPs are privately owned. None are owned by the government. There are no state-owned newspapers. There are no state-owned broadcasters. There are no state-owned internet companies. For the most part, the owners of media properties are publicly held corporations. In other words, private investor shareholders invest the money to create and support and operate these media companies. So a media company does not ever find itself in competition with a powerful state competitor. There's enough competition in the open marketplace, thank you, without the necessity of a state-owned entity. And that has been characteristic of the American media since its founding. And that applies, as I mentioned, to all platforms. And I believe it is likely to remain that way. I would add that there's a small niche, a small share of the over-the-air television market that is publicly owned. It's like the BBC. And it derives its revenues, these stations derive their revenues government-funded corporation, but in large part from voluntary subscriptions, fees paid by the listeners that are voluntary, but very, very, very significant. Unlike the BBC, the United States does not impose a fee on the ownership of a radio receiver or a television set. And in the UK, as you probably know, the fees from the owner of a radio receiver or a television set has to pay an annual fee, and that goes to support the very professional, very excellent work of the British Broadcasting Company, BBC. There is no counterpart in the United States to the BBC. Now, let's spend a moment, and again remind you, invite you to question or raise comments. Let's consider the whole licensing scheme of over-the-air radio stations and television stations. In the 1930s, when the radio industry was just bursting at the seams, there was no regulation. As a result, competing nearby radio stations blocked each other out because of interference. And it was the industry itself that asked the American Congress and the government to intervene and, for heaven's sakes, please regulate us, because we can't regulate ourselves. We want a system where a fair, open, transparent government agency allocates licenses, and so the Federal Communications Commission was born, and it undertook to allocate chunks of the spectrum along frequency lines that ensured that there would be no interference. So there were winners and there were losers. The Federal Communications Commission, acting at the behest of Congress, adopted regulations that provided a license to a broadcaster to operate in the public interest, convenience and necessity, for a period of years at an established frequency, and for using at certain hours of the day over a particular territory. And so that system, with which you're undoubtedly familiar, produced a vibrant and prosperous radio industry. But what about content? Could the Federal Communications Commission have something to say about what the broadcaster aired on his facility? The FCC established network rules that limited the number of stations that a single network could carry. NBC, National Broadcasting Company, challenged that restriction as being in violation of the First Amendment to the Constitution, that said that Congress could not impair or infringe on their right to free expression. So NBC wanted a wide field. They opposed regulation. They thought it violated the Constitution. And the United States Supreme Court said this: radio is different. No one has a right to own a radio station. The airways belong to the public, and a radio station owner acts as a trustee, a fiduciary for the public at that frequency, over those years, at that power. And so in order that the public interest be served by this trustee, it's okay for there to be reasonable regulations on radio that could never apply to newspapers, because there are no physical limitations, there's no spectrum scarcity in newspapers. And so that produced a characteristic that some light regulation, by no means harassing regulation, could be imposed on radio station licensees consistent with the public interest, in order to ensure that the broadcaster operated in the public interest. So, rules about broadcasting indecency were formulated. Rules that ensured that if a candidate for public office was given airtime, free or paid, his opponent or opponents could buy airtime as a matter of right at the lowest unit cost for a broadcast minute, all consistent with the idea of trusteeship and fiduciary obligation. This is called the Equal Opportunity Law. Is there a law that requires a station licensee to grant equal time, free time to all candidates in the run-up to election? No. A broadcast licensee, both radio and television, is obliged to give equal opportunity if a licensee sells time to one candidate, he must make a similar offer of sale time to an opposing candidate. A law like that could never apply to newspapers, because there's no theory of trusteeship or spectrum scarcity that would apply. And this equal opportunity idea I mentioned applies both to radio and television. And that leads to a very disturbing development that has emerged in the age of television. And it is this: television advertising in a political campaign is the most effective, cheapest, most powerful means by which a candidate runs for office. Television advertising is the winner-take-all campaign device in the United States. There are virtually no restrictions on what a if he has hundreds of millions of dollars in his war chest to buy advertising time on local television, he will spend it, and the United States Supreme Court has equated money with a political voice, and since it's not permissible under the Constitution to silence or to moderate political voice, the courts have said you cannot moderate or ameliorate or limit spending of money in any fashion on television. It should not surprise you that the television industry is enormously dependent on the inflow of billions of dollars to buy advertising time by the Republican candidate or the Democratic candidate running against each other, or Barack Obama running against John McCain or Mitt Romney. So the unfortunate result is that the television industry, the over-the-air local television stations, are inundated with campaign cash. This is legal. It's above board. No cash is involved. It's all checks, and it buys good advertising, bad advertising, negative advertising, in the city of Denver during the last campaign, there were, in the last couple of months of the campaign, there were 55,000 spots by the competing campaigns. You could, if you were in a state that was closely contested, such as Colorado, you could not avoid a tidal wave of political advertising. And that has caused a codependence between television broadcasters on the one hand and the political classes on the other hand. They both need each other enormously. And that's an unhealthy situation in my judgment, because it dilutes the independence of television stations in their news gathering editorial capacity, and makes them more unwilling to undertake serious investigative reporting of either incumbents or the challenges. Radio is less involved or less guilty of this tidal wave of campaign advertising, but it remains a fact, as I mentioned earlier, that candidates find that television works to deliver their message as no other medium can do. So long as that phenomenon remains in effect, I think we're stuck with that role. I might add one thing. In the former Soviet bloc, a number of legislative changes were made to provide a level playing field in the run-up to elections, such as requiring free airtime to all candidates and the multiplicity of parties, number one. Or number two, imposing a moratorium on coverage or advertising in the last days before an election. Those kind of rules were, I think, a logical response to the transition to democracy. They created as many problems as they solved, but I would just point out that no such restrictions, no such regulations impact American radio and TV. The ads, the coverage can continue right up to the close of the polls. We don't have half the number of time zones that Russia does. We have, what, 4? And so you can appreciate the small scale of our problem. If the polls close at 9 o'clock in New York, the polls are open for another 3 or 4 hours in California. What if the results of the polling in the most eastern time zone are announced while the voters are still standing online in California to vote? Is the announcement by the press going to suppress the vote in California? Probably it will. Can the government prevent radio, television, internet from announcing the closing, the results in the Eastern time zone in order to provide a fair election out in California? The answer is no, because the information is real, it's accurate, and it's only anecdotal evidence that there has been suppression, but that's a little off the finance, but it shows the tendency toward non-regulation, which is a consequence of our First Amendment. Sir, your question.
Yes. What if we pick particular time frame, somewhere in the middle, right? So polling stations will open a little bit earlier at one point, a little bit later at another point, and then finish the same time. 4 zones, it should be doable, right?
We're victims of a federal system which grants a lot of sovereignty and a lot of autonomy to the 50 states in the District of Columbia. There is no standard poll closing time, and there never will be. The political classes cherish their control over local polling regulations, and they are not going to transfer that power to the federal government. So the idea of a uniform poll closing on their system to remote communities that the signal of the broadcaster could not reach otherwise, that enlarged market provided just enough additional audience and advertising revenues to bring the television industry back into good health. But it required the government to commandeer up to a third of the capacity of the cable systems in order to comply with this must-carry law that Congress passed over the strong objections of the cable industry, but at the strong insistence of the over-the-air television industry. Television won, cable lost, politically. Now, the cable system industry did not take this lightly. They brought suit, claiming that their First Amendment rights were violated because they were obligated to use up to maybe a third of their capacity to carry the signals of an industry against which they competed. Now, this posed a serious problem for the United States Supreme Court. There were precedents that said that the First Amendment prohibited a law from requiring a newspaper publisher to publish political content that it didn't want to carry. The television industry argued in the United States Supreme Court, along with the Federal Communications Commission, that there was a compelling public need for this law, because without this law, the television industry would deteriorate and go in a downward spiral. And what would suffer? Local coverage. So, in order to protect the industry and protect local coverage, the United States Supreme Court said this regulation did not impact content, did not impact what was carried, but was neutral in its impact. And since there was a compelling public need for this, the United States Supreme Court found that this must-carry legislation did not violate the Constitution, even though it commandeered unused capacity by the cable industry, and it recognized there was competition, and that there had been instances where the cable industry had refused carriage for competitive industry. It remains a sore point. This remains an issue in the Republic of Georgia, where our NGO, International Senior Lawyers Project, has assisted the Georgia National Communications Commission and NGOs and the industries, communications industries in Georgia, to come up with a fair reconciliation of the needs of the public for local coverage on the one hand, and the fairness of treatment of the cable industry. Yes, sir.
Once again, if we compare radio and newspapers, cables, it's something which you can add on. You can build new cables. So if air television is having troubles with distributing their signal, why don't they provide more cables, right? So it's not something which you have to divide all this. You can just build more infrastructure.
That's a good question. What the United States Supreme Court observed was that there was a difference between newspaper and cable in this respect. At least as in the 1990s, cable system operated as a gatekeeper, as a bottleneck. It could and did cut off signals it did not wish to carry. And it prevented the public from seeing programs that it might otherwise want. So the unusual monopoly gatekeeper bottleneck qualities of cable were different from newspapers. Newspapers didn't prevent you from reading a competing daily or getting information from any other source, and that difference between the attributes of the two platforms can help explain the difference. And that leads us to a somewhat related question about two platforms and the problem of diversity and plurality of voices, which is a concern. For many years, the Federal Communications Commission has said that a broadcast licensee in a particular market may not own a newspaper in that market. These were called the cross-ownership rules. The fact is that in those markets where there had been cross-ownership, where a newspaper and a television station had a common owner, the fact is that the profits from the newspaper station subsidized the editorial operations of the newspaper. So the newspaper was dependent on the economic health of the broadcaster. Now, Federal Communications did not require any divestiture of the common-owned newspaper and licensee in the same market. But they said in the future, no licensee of a radio station or television station could acquire a newspaper. And the whole purpose was to encourage a diversity and plurality of voices, so that a medium-sized city might not be under the control of an American oligarch who was the publisher of the only daily in town and the owner of the dominant television station in the community. It makes some sense, but it seems on its face to violate the idea that Congress shall make no law abridging or violating the freedom of speech or of the press. The courts have taken challenges where newspapers have said that this cross-ownership rule violates our ability to express ourselves through multiple ownership. And the United States Supreme Court said this regulation is modest and in the public interest and will withstand a constitutional challenge. This area remains controversial. It is unsettled. But the unintended consequence of the cross-ownership rule, the rule that said that a broadcast licensee may not be owned by the only newspaper in town, it has had the effect of discouraging big mergers. let's take the example, the hypothetical, of a Gannett corporation that owns, let's say, 80 newspapers in 80 different communities. But it wants to acquire, let's say, XYZ corporation that owns 30 television stations. But 15 of those television stations are in markets where Gannett has a newspaper. Now, what are the options to require XYZ Corporation to divest the 15 television stations in markets where there's a Gannett newspaper? Are there any economic advantages of that kind of a deal? Probably not. So the merger fails. It doesn't go through because there are no financial advantages of requiring the acquired company to divest itself of half of its assets. So the unintended result of the cross-ownership rule is to discourage bigness, encourage competition. I don't think anyone foresaw that, but that's been one of the rare instances where regulations improved competition rather than discouraged competition. A couple of words about copyright. Media companies are schizophrenic when it comes to copyright. They are owners of copyright of their own content, aren't they? And they consider that an important asset, the ownership of the copyright in their own content. But a media platform, a media company to exist, is interested in what other media of a variety of platforms reports. So they're interested in acquiring some part or all of the copyrighted content of their competitors. So on the one hand, you're a protector of your own copyright, and on the other hand, you might be a predator of the copyrighted content of other platforms, whether competitors or not. Now, how do you reconcile that? To overcome the problem of schizophrenia? Because no news organization can survive relying only on its own staff. They have to search the web. They have to read what the competition is reporting and to chase those stories at the very least. But a mutual friend of Theodore's and I, David McCraw, Assistant General Counsel of the New York Times, has said the New York Times at least follows the golden rule of copyright, and that is treat your competitor and your competitor's content as you would have him treat your content. That's a rough and ready rule, and it has produced a modus vivendi among platforms. There remain predators, and the copyright laws are available and used by news organizations to punish the predators in litigation. And since the emergence of the internet, a new force has emerged search and find breaking stories, important stories, interesting stories, good stories, summarize them, post them on the web, pass them off as their own, no attribution from the originator. And these aggregators would support themselves with advertising. And there's a certain fundamental unfairness in that process, because it can be done virtually by robotics. It takes no skill, it takes some technology, but what does it do to the time, expense, money, sweat, and professionalism that brought about the reporting of the original breaking news story by the originator? If AP has a story that let's say, for instance, the Pope has developed a fever, and posts the story to his members and on the web, you'd have to go to the AP website to find it. But the aggregators, or scrapers, spot that story, grab it, use the same or similar headlines as the Associated Press in seconds or nanoseconds from the time that the AP posted it, and pass it off as its own. And the visits to that website, because of its ubiquity and its timeliness, competes unfairly against the Associated Press, who had to pay overhead, salaries, and all the costs of running a multi-million-dollar cooperative to get that news story out about the Pope's fever. So the Associated Press and other news organizations who are in a similar position, and in other words, originators, reporters, news gatherers, legitimate news organizations publishing breaking news and important news, found themselves being nibbled at by these predatory aggregators or scrapers, and losing revenue and market share. And they went back to a famous case involving Associated Press in World War I, a case that developed a so-called hot news doctrine to regularize and make fair the competition between competing news organizations. Associated Press had war correspondents at the front in World War I, reporting back to the subscribers and members in the United States. They competed against the International News Service, which was owned by William Randolph Hearst, an oligarch of, if there ever was one in the United States. The International News Service, the INS reporters, lost their accreditation from the American military. And they were all dressed up and no place to go. What they did was methodically, systematically, steal the AP story and publish it as their own. They would change words. Why? To avoid a copyright lawsuit. They changed headlines. Why? To avoid a copyright lawsuit. Now, how does AP respond to this? Well, the AP brought a lawsuit. As old as I am, I wasn't around for that lawsuit in 1917. But the United States Supreme Court found that this was unfair competition, that the Associated Press had developed a quasi-property right in its breaking, originating news stories sufficient that a competitor who grabs that information and publishes that their own, passing it off as their own, competes unfairly. The Hearst International News Service said, well, the First Amendment protects our right to publish news, and we didn't violate the copyright laws. But the court found in favor of Associated Press and against the Hearst International News Service because of a fundamental problem of unfairness. And so, even today, with the ubiquity and the immediacy of the internet, the rule established in 1917 that protects the originator of hot news, the gatherer of hot news, the producer of good news, of hot news, is protected. So Associated Press and other news organizations have won lawsuits which punish the aggregators, the scrapers. I mentioned earlier about the codependence between political candidates on the one hand, political parties on the one hand, and the local television industry. There have been legislative efforts to regulate campaign spending, to regulate and restrict politicians from buying elections just through the lavish expenditure of funds, so that only the wealthiest candidates and the parties that are most successful at fundraising will prevail. And this is capitalism on steroids in a political setting. So efforts were made to put a cap on how much a candidate could spend. Efforts were made to put a cap on how much individuals could contribute to a campaign. Remember, Barack Obama used the internet with enormous effectiveness in 2008, reaching millions of people to raise funds through web appeals, mostly young people. Congress was particularly concerned about the use of corporate funds to advertise in connection with elections. Banks, mining companies, telco companies, or labor unions that supported the views of the campaigns. This was the so-called soft money problem, where there were no limitations on corporations and labor unions buying time on television in sophisticated advertising that, if you read it carefully, supported one candidate or another. So Congress put a strong restriction on that kind of use of corporate funds to buy time, independent of, but in parallel with an effort to elect one candidate and oppose another candidate. It was a well-meaning effort to control the flood of corporate funding into elections. plausible basis that, that the corporate voices, the union voices, were too dominant and too ubiquitous in terms of their impact on campaigns. Frankly, there was no hard evidence that mere money buys election. Believe me, there was no hard evidence that big expenditures bought election, because it's an arms race. And both major parties can outspend themselves and their predecessors and their competition in any race. So Congress attempted to regulate, to restrict that spending. In other words, a corporation couldn't spend its corporate treasury on advertising up to 30 days before the general election in November of the even-numbered years when we have our congressional elections, or every 4 years when we have our presidential elections. So corporations had to stop writing checks 30 days before the election, even though they really wanted to support this candidate or oppose that candidate. And that brought about a very important constitutional challenge to that. It was decided 4 years ago. It was called the Citizens United case against the Federal Election Commission, and it was a direct attack on the constitutionality of that limitation on corporate spending. Remember, I mentioned earlier that the court has made analogous spending and voice. Spending equals voice. With that premise, with that predicate, the United States Supreme Court looked at the fact that earlier cases had found that media corporations, like, let's say, News Corporation owned by Rupert Murdoch, or the Gannett Corporation, these media corporations were corporations like any other corporations, except they owned media properties, and they could not be restricted in how they spent their money in editorial endorsements, in coverage, in the way they covered campaigns. Because for the government to try to restrict a media corporation like Murdoch or Gannett in its coverage of a campaign would surely violate the Constitution. So we have this subset of corporations called media corporations who were properly exempt from regulation because of the First Amendment, and properly so. But other corporations like Mobil or Bank of America didn't own media properties, and they could be regulated. Does this make sense, that there's this disparity between regulations? And the court found that that disparity, that disparate treatment, discriminatory treatment, could not stand. So non-media corporations were given most favored nation treatment with media corporations, so that all would be free to spend their corporate treasuries as they wish on supporting candidates, making independent support of candidates. So the odd outcome is that the media corporation became the tail that wagged the dog of deregulation, of campaign restrictions on corporations in general when they spend money independently of candidates in the run-up to elections. Very controversial opinion. Very controversial. Fedor, do you have a question?
Yes. Is there any procedure of due diligence in sphere of media law for new business projects or for new entities which are planned to be found in the next future? I mean, can media lawyers somehow prove that some business connected with information would be safe from the legal point of view? And if you do this due diligence, what is its procedure? What its usual practice?
The question of due diligence, and let's just look at the aspect of due diligence associated with government regulation. This aside from the other issues of reliability of funding, of market opportunities, staffing, and the rest. The time the lawyer will spend on government regulation will be a limited period of time, because what I've described is a system of free expression that does not tolerate heavy government intervention, a system that is hostile to government regulation because of the pervasive impact of the First Amendment to the Constitution, which was adopted in 1797, and that continues to have real day-to-day impact. Those 14 words, Congress shall make no law infringing the freedom of the press, speech or of the press, continue to have real powerful meaning today. So due diligence will not focus to any serious extent on government regulation. The one exception would be whether an FCC license is going to be needed for an over-the-air radio station or broadcast station, or if a cable system is going to be created, you'll need the approval of the municipalities where the cable is going to be laid. The regime, the system is libertarian. It's anti-interventionist. It's anti-regulatory, and that climate persists in all media. I mentioned that the Citizens United case continues to be controversial because opponents of the case say that it does not regulate the flood of money, and that it distorts political life. It distorts political campaigns, and puts too high a value on cash as opposed to merits of a particular candidate or referendum. That it's too extreme a projection of the equation of speech and dollars. In fact, however, there has, as I mentioned, there has been no empirical evidence that it's affected campaigns in a negative way because of the parity between the major parties. beneficiaries of and the victims of a two-party system. And so long as that persists, there'll be this arms race for dollars, for airtime, and for political success. And I'll conclude with just a couple of words about the industry. It is no secret that the newspaper industry has undergone particular turmoil and restructuring. Newsrooms are down 30% of personnel compared to 10 years ago. What has suffered? Investigative reporting, local coverage, in-depth coverage. The major newspapers like the New York Times, the Washington Post, the Wall Street Journal still are reliable and heavily read, but they're losing circulation, they're losing market share, and they suffer from the flight of advertising revenues from hard copy to the internet. That's true also of television and radio. The flight of advertising and the flight of audiences. I shouldn't say flight. I should say migration of dollars and eyes to the internet. There is a suggestion that this may be only temporary. We have a multi-billionaire by the name of Buffett who just bought 23 daily newspapers, so he must know something about the prospects of the newspaper industry. I think it's fair to say that with all the platforms competing against each other, there remains an ever wider diversity of views, absence of concentration of ownership, and that's not unhealthy for a democracy that puts store in the free flow of information as being a necessity and a marketplace of ideas that is the hallmark of a free and open society. But it bears watching, it bears analysis, and I'm very appreciative of your interest in the American experiment in media regulation, or I should say media non-regulation, as an attribute of the free market on the one hand, and people who aspire to be a democracy on the other hand. It has its cultural roots. It may have its cultural limitations, but it is part of the continuing American experiment, and you can be sure that if you had a speaker here on these subjects a year from now, it could be very, very different. But I'll be glad to take your questions and your comments.
Okay,
Sir.
maybe just one, to be sure I already have some time. So you mentioned today radio, TV, newspapers. Obviously, internet regulation is something which is like the hottest topic at the moment. So this industry is the only one which is not declining, which is actually gaining all these market shares from all other industries.
Yeah.
It's special in a way that historically since it was like a national project, like 30 years back then, or 35, so some of the regulation is, which is worldwide regulation in a way, but it's still national, right? I mean, some of the top structures of the internet, like ICANN or something, they still reside in the States. It has this extreme speed, right, which is different from this scrapers problem, etc., etc. So, what is the? I know it's very broad, but still, what is the maybe, I don't know, one or two the hottest topic in internet regulation? What should be done now? What is the debate?
I think the question is a good question, and I would say, what is the biggest topic in non-regulation from the American's perspective? There was an effort to require regulation and licensing of the internet, in major part because of the problem of pornographic images available to children. The efforts to regulate the internet were well-meaning and were based on the idea that the internet is like the broadcast industry, and its pervasiveness was such that if the broadcast industry can't be regulated on indecency, for instance, similarly the internet should be similarly regulated by the Federal Communications Commission. In other words, an ISP or a website could be taken down or lose its license because it violated pornography rules. That was the purpose and the intention to regulate the internet. That claim went to the United States Supreme Court several years ago, and there were views on all sides. Is the internet closer to a newspaper, or is it closer to a broadcast station? Should it enjoy the non-regulation of a newspaper, or be subject to the light touch regulation of broadcasters? And the Supreme Court, in a very lengthy analysis of the internet, a very expert analysis, the case is called Reno against American Civil Liberties Union, found that substantively the internet was closer in concept to the newspaper industry, should enjoy the protections of the First Amendment to the fullest possible extent because of its nature. It didn't have the specific spectrum problems and pervasiveness problems of radio and TV broadcasting, which subjected itself to more regulation. And that case resulted in the regime we have now, which is little or no regulation of the internet. So there's no Roskommnadzor in the United States. Websites are not taken down, cannot be taken down. There was an attempt to take down a website of WikiLeaks. Not Julian Assange's leaks of classified American diplomatic and military documents, but an earlier case involving bank records. There was a Swiss bank that had a Cayman Islands affiliate, and a disenchanted former employee of the Bank Julius Baer of Switzerland leaked to WikiLeaks confidential bank documents showing that some customers of the banks were cheating on taxes, evading taxes, and storing their assets offshore to evade taxes. It embarrassed the bank terribly. It embarrassed the bank's customers even more so. The bank went to court to claim that the WikiLeaks posting of its proprietary, confidential customer accounts violated copyright, violated trade secrets, violated privacy, violated the proprietary rights of the bank to its own documents. And a federal district judge had jurisdiction because I think a domain register of WikiLeaks in San Francisco was sued, and the judge entered an order directing that defendant domain register to take down the website, all of it, not just the bank records. And that was a local federal district judge in a brand new case. The press wasn't present. It was just a local domain register who didn't fight very hard. When the news organizations and the internet industry learned of that decision of censorship, pure and simple, they reacted strongly and immediately. And they filed papers in the federal district court. They intervened, and they pointed out to the judge how he had made a mistake, that the First Amendment of the Constitution protects against censorship, protects against prior restraints, protects against injunctions against the flow of information. They cited the Pentagon Papers case, and the judge realized the mistake he made, and he eliminated his order. So the order was vacated, and the attempt to take down that WikiLeaks site failed in the final analysis. So the law against prior restraints, which is a fundamental part of the First Amendment, would prevent that sort of thing from happening again. Frankly, even if the judge's order originally had stayed in effect, it would have been ineffective because WikiLeaks had circumvention technology, mirror sites, and proxy servers so that they could easily circumvent, evade the judge's order. So the bank records were still available globally, but just at that California site. Let's say if Edward Snowden were in the jurisdiction of the American courts, and he was about to leak some more of his top secret documents from the NSA, he could be prosecuted criminally for violating laws against release of classified information. But the odds are that he could not be censored in advance. He could not be enjoined in advance from releasing that, unless the government proved that there would be irreparable damage, serious damage to American national security interests. It was my law firm, my partners, successfully argued in 1971 that the publication of the Pentagon Papers must continue, that the government did not have the evidence to show that there would be irreparable damage, and that there was a heavy presumption that any prior restraint, any censorship is unconstitutional and must fail, and we succeeded on that. So with the strength of the precedent of the Pentagon Papers case, the First Amendment, websites are not going to be blocked. They're not going to be taken down. Other comments, questions? Sir.
So why this FCC licensing regime was so concentrated on states level, not on federal level, when the nature of radio waves is such that it is that states' borders are very transparent for those waves. So from one state to another,
By states, do you mean nation states or
American states?
American states.
Yeah.
The Federal Communications Commission, the FCC, the licensing authority, is a national government, is a federal government, and it does not look at state borders. The state borders do not count. If I made a suggestion that they do count, they're not. So this is a national regulatory system that does not consider state borders. So a television station atop the Empire State Building in New York City can reach Connecticut, New York, New Jersey, perhaps parts of Pennsylvania, and that doesn't make any difference. So the states' rights, the rights of states to their own information spheres, is trumped by overcome by the national communications policy. Hi, Jacqueline.
Hi. I have two questions, I guess. The first is how, from your perspective, from focusing on the U.S. and then looking outward, how would you see attempts by some states to treat online content more broadly, not just the content of news outlets, but blogs, anything that people puts online as media, and subject it to all media laws? The second question is, I don't know very much about this, but I know in the last few years there's, as in the U.S., in a lot of countries there's been digitization of television, and my sense is that that's had significant effects on the market for local television stations, and that's had been an excuse in some cases for political pressure to sort of change the market in certain ways. I'm curious how that has played in the U.S. and what analogies might be drawn.
At the ITU conference last year, some of the mature democracies were able to fend off, at least for the moment, efforts by some nation states to use the ITU as a vehicle to impose standards, norms on the internet, and that will be a continuing battle. The People's Republic of China, for instance, has for years argued for a internet regulation under the auspices of the United Nations or the ITU that would purify the internet, that would regulate content in a way that can only be regarded as authoritarian. Those pressures from states like the People's Republic of China will continue, and they will have colleagues and allies among political classes of states where the internet is found to be anarchistic and a source of intolerable dissent. That's another case where an arms race is in effect, where forces of the status quo being an essentially unregulated internet will be opposed by those states which wish to regulate the internet, that's a moving target. That's a work in progress, and the mature democracies have a lot on their hands to try to resist the efforts to regulate. The fact that ICANN has a contract with the United States Department of Commerce, or had, creates some political and atmospheric problems. But it's too early to say whether we're living the golden rule or the golden era of the internet, and it's going to come to a predictable regulatory end, or whether the status quo will persist, or whether there'll be a succession of intranets like that created by the great Chinese firewall. But there again, the genius of the technology entrepreneurs makes an arms race of the technological efforts that the entrepreneurs of technology, at least some of them, see it as their goal to maintain the anarchistic status quo by using technology, whereas some of the repressive regimes, like that of the People's Republic of China, use their technological genius to do just the opposite. It's an open question, and I don't have an informed prediction. Jacqueline.
Just the other question about the digitization of television.
Yeah.
Now, maybe I'm way off on how I'm describing that, but...
Jacqueline, in all candor, that's beyond my pay grade.
Oh, no worries.
I have a T-shirt at home that says, "I'm an English major. You do the math." So I can't speak to the technology of digitalization. Sorry.
Thanks.
Okay. Thank you. Thanks for your attention. Thanks for your questions. Thanks for the opportunity to talk with you about a subject that I really enjoy, with the exception of digitalization. But thanks for your attention, and good luck to all of you. Thank you.
Actually, based on our